everyone, and welcome back to another episode of Law Schoolers. This is our final episode about perfection. Next episode, we're going to be talking about priority when it comes to secure transactions. But in this episode, we are going to be focusing on maintaining perfection. This is something that we kind of talked about a couple episodes ago about other perfection methods, and we talked about some of the other documents that are related to the financing statement. One of those documents was the continuation statement. Well, that's one of the ways that you maintain perfection is through, the continuation statement. What's important to realize is that if there's a gap between perfection methods, then it'll be as if there was never perfection at all. And that party will be as if they were never perfected, and so they lose their place in line when it comes to this priority, and you can't step back into line. So what I'm really saying here is if you step out of line, you step out of line, nobody can save your spot for you. You have to move to the back of the line if you lose that place. So all about maintaining perfection is just standing in line, keeping your spot, and making sure that you need to do what is necessary to maintain that spot. So, how do you do that? Well, in our other episode, we talked about the continuation statements. Perfection needs to happen. Well, perfection, the financing statement is good for 5 years, and then you have to file the continuation statement. You can do that as early as 6 months before your perfection is about to expire, and then once you file that continuation statement, perfection continues for another 5 years. And you just kind of keep this cycle going until there's no longer a need to have the collateral secured, either because the debt is paid off or the collateral no longer exists. So what happens if there is a gap other than you lose your spot in line? What's at stake for the lawyer if they are not diligent in maintaining perfection for their clients? Well, it's very easy to become liable for malpractice for failing to maintain perfection. You can be liable either because you failed to issue a continuation statement, or you can be liable if you fail to disclose that a continuation statement is necessary to your client. So we have here Barnes versus Turner. What happened here? A continuation statement was not filed, and the lawyer did not even tell their client, hey, you should file a continuation statement for this collateral. And that creditor lost their spot in line, so they sued the lawyer. And the lawyer was trying to argue, look, I didn't need to disclose it. It's not my responsibility to disclose something this simple. What the court ends up saying here is you're either required to do the continuation statement because it's so simple to do that, or you are to disclose that because, honestly, that's even easier to do that. So because it's super easy to do, the lawyer should have just done it. What are some of the important changes that might affect the perfection status? Well, if there's a change to the collateral or perfection method, if there's a new loan, if there's a new debtor, if there's a new secured party, all these things may affect that perfection status. The secured party hardly affects the perfection status because the financing statement focuses on the debtor's status, but if you've got new collateral, if you've got a new loan or additional loan, or if you have a new debtor, well, those things are going to change it. So what about changes to the collateral or the perfection method? What things there can affect your perfection? Well, let's talk about after acquired collateral. What is after acquired collateral? This is collateral that is acquired after the original financing statement and the original secured transaction took place. So we have two questions that we need to ask. First, is the newly acquired collateral attached to the original financing agreement through a newly acquired collateral clause? And second, if it is attached through a newly acquired collateral clause, is the financing statement also going to be sufficiently broad enough to perfect that newly acquired collateral? Essentially what we're asking here, question 1, does it attach? Question 2, is it perfected? Same analysis as the original collateral, but we're doing it in a different way because this is coming after. Is it going to, in a sense, relate back to this original collateral, or are we going to have to file a new financing statement and do a whole new secured transaction for this material? If the answer to either of these questions is going to be no, well then the secure party is they are going to have to file that step of attachment or that step of perfection for that new collateral. Again, if you want your place in line to be saved, you gotta step in the line, either through attachment or through perfection. Okay, what about proceeds? Well, what are proceeds? And how does this apply here? Well, we talked about proceeds when we talked about attachment, so I won't cover it a ton. But proceeds, a basic way of understanding it is what is generated from the collateral that is secured. Well, what about the perfection of proceeds? As long as the original collateral was attached and perfected properly, proceeds are going to automatically attach and perfect. The issue with this is that perfection for these proceeds is going to last for only 21 days. This is outlined in section 9, 315, subsections C through D. And any proceeds require additional perfection to avoid a lapse. So you're given this buffer time to continue perfection in these proceeds by doing, say, for example, a financing statement. So there are 3 ways to extend this perfection, and this is actually something that I struggle with just a bit of understanding. So I'm going to read this for you, and I won't spend a lot of time expounding on it because I don't want to get it wrong. I know what I've written down is right because it follows the sections, section 9, 315, C through D, but the explaining it's going to be a little hard for me. The first way that it could extend perfection in the proceeds without filing a new document for it is going to be called the same office rule. Well, how does the same office rule work? There's 3 conditions that need to be satisfied. First, the financing statement covers the original collateral. So, original collateral proceeds. If the financing statement does cover the original collateral, it's properly perfected. Good to go there. That's step number 1 for this. Step number 2 for this is the proceeds could hypothetically be perfected by filing a financing statement within the same office as the original collateral. What's that mean? It could be perfected by filing a financing statement in the same state, Secretary of State office, as the original collateral. So original collateral perfected, same office, same state, good to go there. Step 3 of this step condition is if the proceeds are not cash and are not acquired with cash, if it's not cash and if it's not cash proceeds, well then it could follow the same office rule. So, proceeds aren't cash or cash proceeds. If there's an existing financing statement in that same state as the new proceeds, well then you don't need to file a new financing statement for the proceeds. That automatic perfection will continue past those 21 days. Okay, so that's way number 1 to prevent a perfection lapse for proceeds. Way number 2 of avoiding a perfection lapse for proceeds is if the proceeds are identifiable cash proceeds. You don't need to follow the same office rule there. This is the one that I don't really understand, but you're really just going to look at the definition of cash proceeds. That definition of cash proceeds is found in section 9.102A9. And then you're also going to look at section 9.315D2. That's going to give a good example of how that works. Okay, so that's number 2, if it's cash proceeds. Method number 3 is if the security interest is perfected by another perfection method within the first 20 days. So, what's that mean? Having a financing statement that covers all assets already talks about all the assets being perfected. So, You don't need an additional financing statement for those proceeds because the financing statement already covers all assets. It's broad, it covers it. So that you're good there for perfection of proceeds. The third part of the changes in collateral or the perfection method is going to be the location or classification. What happens if there's a change in the location or classification of the collateral? Well, depending on what caused the change will determine if that collateral needs to be perfected again. So, we are going to ask a couple of questions. First, does the financing statement still describe the collateral and there was no change in the perfection method? In this situation, regardless of the change in location or classification, there is no need for a new financing statement to be filed. Another question that we need to ask, does the financing statement no longer describe the collateral? Well, in this situation, a new filing is needed only if non-cash proceeds were obtained with cash proceeds. Again, I would refer you to the definition of cash proceeds in Section 9102A9 to help make a little bit of clarity there as well. The third question we need to ask is, was there a change to the perfection method when it came to location or classification? Meaning change in perfection method, I'm talking about changing possibly from a financing statement to possession, or maybe going from possession to a financing statement. Well, if this is the case, immediate action is going to be necessary if the cause was a change in the location or use, that is the characterization of the collateral. So, let's take an example for this. You've got a car dealership. This car dealership has inventory. Say this car dealership takes that inventory, one of their vehicles, and instead of putting it on the lot to sell, they use it to drive to a neighboring dealership that they also own. And this car is now used for transporting employees between it. Well, how's this changed the classification or the characterization of the collateral? At one point it was equipment, and now it is going to be, at one point it was inventory, a good to be sold, and now it is equipment. It is a good that is being used in the as part of the business. Not to be sold, but as maintaining the business. Well, if there's a change to the perfection method, meaning if your financing statement covers only inventory, and now this is equipment, then you need to file a new financing statement immediately to avoid this lapse based off of this change in location or classification. So, those are changes to the collateral or perfection method. Now let's talk about changes to the loan. How does the changes to the loan affect perfection? Well, usually changes to the loan amount is not going to change perfection status. Pretty simple, pretty straightforward. But there may be potential changes depending on whether there is a future advances clause or if the transaction was a PIMSI. I won't get into how those changes might affect it, but the general rule is that changes to the loan are not going to change your perfection status. What about changes to the debtor? Well, there are a few ways that debtor's information could change. Their name could change. The debtor's location could change. There could be new debtors, and these debtors could also go into bankruptcy. How do all of these different scenarios affect perfection? Let's start with a name change. After a name change, the original financing statement is going to be effective for 4 months. During that period, a new financing statement needs to be filed to make sure that there is no lapse in perfection. You've got a 4-month buffer. This rule is outlined in Section 9506 and 9507, subsection B and C. Okay, what about the debtor's change in location? Well, this is outlined in Section 9.316, subsections A and B. If the new address does not alter the governing law, meaning you're in the same state, well, then there is no need to refile. But if the governing law does change because you're in a different state, well, then the secured party has 4 months, unless the financing statement is going to expire before then. You've got 4-month buffer to issue a new filing. If it's whichever is sooner, the old financing statement expiring or this 4-month buffer. You need to file a new financing statement within that time. If you don't, perfection is going to lapse. Again, this kind of makes sense because if they're in the same state, it doesn't make a difference. The debtor's change of address. If you're searching the debtor's name, the address might be a little confusing that it's not the same, but you're still going to find the debtor's name. And so this is going to be an error, but not a seriously misleading error. What about new debtors, changes in the debtors? Well, if there is a new debtor who authorizes an amendment, the secured party may file an amendment to add or remove a debtor. Security interest in the new debtor's collateral becomes perfected from the time of the amendment, not from the time of the original perfection through first having attachment and then the perfection method is going to be this new collateral. This new debtor's collateral is going to be perfected at the time of the amendment. This is outlined in Section 9.15, subsections D through E, and Section 9.509, subsections A through C. And then bankruptcy has the effect where you can't acquire new collateral, but you can maintain existing financing statements. Bankruptcy is pretty unique because you have a stay on all these things, so you might not be able to collect on the collateral, but you can keep your place in line. You obviously can't add any more assets because they don't have any more assets to add. All those things have a stay, but your interest does not go away. So you can maintain your interest and your priority through the debtor's bankruptcy. But other than that, everything else is going to be put on hold when things are in bankruptcy. Okay, so that's maintaining perfection. Lots of things that we talked about. We talked about how easy it is for perfection to lapse and how liable lawyers may be for allowing that to lapse. And then we talked about how changes in the collateral or perfection method in the loan or the debtor might affect your perfection and what you can do in those situations to maintain perfection. There's lots of little subcategories underneath those things too, but that's everything that we talked about in this episode. It's been busy. It's been fun. Have a good one. Bye. Thank you for listening to this episode of the Law Schoolers Podcast. If you enjoyed the show or the material shared on the Law Schoolers website, you can support Law Schoolers by becoming a patron at patreon.com/lawschoolers. I also wanted to provide a quick disclaimer. Nearly all Law Schoolers material is unedited due to the sake of time and a desire to keep the content as raw as possible. Additionally, the material is only provided for educational purposes and is not to be used as legal advice. If the material is used as legal advice, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show.